Well, greetings to each of you, and welcome to another episode of the Shakedown, a podcast about corrections, for corrections, and by corrections. I am your host, Aaron Dawson. As always, good to be back with you this week on a all brand new episode as we continue the conversation with Miss Alisa Brodkowitz, the CEO of Lightning Law. If you caught the first half of the conversation last week, I know there were some things in that conversation that kind of caught you off guard. There were some things in that conversation that kind of shocked me as we were having the conversation. But wanted to make sure that you had the opportunity to hear the second half of the conversation. There was a case that was heard in the 11th Circuit, was sent back to the courts to consider another piece of it, but Ricky Christmas versus Lieutenant Nabors. Interesting case, and Alisa and I will discuss that, the Prison Oversight Act, and then some other case law and legal mail concerns. But guys, this is a topic that usually isn't real high on our radar, but it's something that could be a major issue if we don't handle it properly. Not that it's something to have anxiety about, but something to make sure that we are aware of and handling appropriately. So, having said all that by way of introduction, let's get into the second half of this interview.
So, I know you're familiar with Christmas v. Nabors. I want to boot it over to you to ask me if you have any specific questions or where you want to start.
Well, just, when it came across, and the agency that I came from, just to kind of give you some context for why it piqued my curiosity. The agency that I came from, the way we worked around the drugs, the paper being soaked in narcotics was, we'd have the inmate come to a supervisor's office. We'd open it in their presence and we'd photocopy their legal mail. They'd get the copy, and then we would shred the original and the envelope in their presence so they could verify that, and that we never did anything with it untoward, malicious, so and so on. And then we had a form they signed basically saying they witnessed all of this, so forth and so on, one in their inmate file, to try to avoid both sides of that, that we're not in possession of it unnecessarily. And if it was soaked in drugs, it's now in this, shredder bin over here and nobody's getting anything out of it. But, when I read that case and it came through, and the key component was the memory in that technological device, it made me pause for a second and think, wait a minute, do copiers have memory? Do they have memory cards in them? And the gentleman that took my place when I left the county, I called him and was like, hey, bud, you might want to check the copier, find somebody that knows something about copiers. And that, here we were thinking, we're great. We're way overshooting this. We're doing fantastic. I'm thinking, man, we've been doing that for 2 or 3 years. So if there is a memory card in this copier, oh my word.
Yeah.
So I guess the conversation when you and I were discussing a jail con, and I thought this is a perfect opportunity to discuss this, is how rampant do you think, rampant might be the wrong word, common might be a better word. How common do you think this is going to be based on this case coming through the 11th? How common do you think this is? Is this just the tip of the iceberg? Is this, the proverbial camel sticking his nose in the tent kind of thing? And we're going to have a barrage of stuff following after this? Or do you think this is a pretty weak attempt at trying to make a case where there may not be one?
Well, okay, so let's first summarize this case for anyone who hasn't read the case or actually listen to the case. I love technology and the fact that this case is the audio recording of the oral argument in front of the 11th Circuit is actually available online. And I listened to it because I was really interested in what the questions were from the commissioners on that Court of Appeals. So this is called Christmas v. Nabors. It's number 21-14230. It's a decision from the U.S. Court of Appeals for the 11th Circuit, and it came out on August 8th, 2023. So if anybody wants to look it up, they can read the actual precedent, or they can listen to the pre-decision making, where they're just asking the questions at the Court of Appeals level. So that case stands for the proposition that you cannot do things that chill speech to and from the incarcerated individual and their attorney. And what the conduct was that the court found chilling was scanning in documents, legal mail from an attorney into a computer, where the individual would then log in, and where the court administrators also had a login and could potentially view those documents, and where the scanner had a memory card, and someone could potentially use that scanning memory card to see the documents. So there was never an allegation that anybody actually saw those documents or read those documents at the jail. But it's that fear. I can't speak freely with my attorney because somebody could read it.
Yes.
So I thought it was a really fascinating case because it holds so strongly to the chilling speech aspect, and it makes it crystal clear that whatever tech is used to share legal mail, only the incarcerated individual should have their password. That the password that gets them to their own legal mail, nobody else should have it. They should be able to reset it if they feel like it's been compromised, just like the way we do with our own email. So I thought that was interesting. Just like you, I turned to do some research on photocopiers because I realized that that's something I've heard, is that facilities will use a photocopier, copy it for the individual, and I think that, raises a couple concerns, because if you are putting documents in a machine, even if, a lot of machines sort of like the documents face down. So, but some machines, they face up, or you've just opened it and you need to put it on the machine. You could have read the first page. Those actions in and of themselves are concerning, because that is activity that could chill speech. And the other part of this case that I think is, from an administrator of a jail point of view, scary, is that the court is allowing this case to proceed against the individuals who work at the jail, not just the jail. So in the Nabor's case, the issue was, are there valid claims against Lieutenant Nabor's and Sergeant Hill in their individual capacities? And the court said yes. Supervisor may be liable for the unconstitutional acts of their subordinates when they participate in those acts, or there's a connection between their actions and the violation of the constitutional rights. So if you don't stop your own employees from engaging in these practices, then you as the superior can be held responsible in your individual capacity. And all you're doing is going to work and trying to do the best job you can. And suddenly you're being held responsible for violating someone's constitutional rights. That's scary.
Well, and have you seen in whether, obviously this decision, my understanding is that the courts basically said that there was no evidence of any maliciousness, nefariousness, or anything like that. So they could not prove that they were harmed in any. There was no harm caused, and my wording may be off on that, but that when I read it, just looking at it, was the potential is there for a problem, but in this specific situation, you have not, there's no evidence of any harm being done. But in
So I would
whether it be
say
this,
that the harm that was that the court found that there are valid constitutional claims, and that's the harm. The potential harm is the violation of the constitutional rights. So the court said, this case gets to go. This case can't be thrown out. This case is going back to the district court so that they can measure the harm. You know, how do we compensate this person? How do we restore their rights? What do we do to make them whole? So I think maybe what you're saying is no one actually read the documents. They were
Right.
not actually used against Mr. Christmas.
right.
But his fear that they could be used shows that his speech was chilled, and he has a legitimate case for my rights were violated.
Yeah. Well, and in obviously this is still ongoing, so we don't know the end results of this. But in other cases, have you seen? And obviously this may differentiate between different circuits, but have you seen a willingness from the courts to really consider the individual action, as in, okay, I did something, I put it on the copier face up, so technically I could have access to read that top page, but there's no evidence that I'm doing anything with it, that I don't have a history of it, so forth and so on? Or is the focus with a little flexibility there from the courts as far as, okay, you're going to have to show me that they're doing something with it? Or has it been more the other direction where, hey, the potential is there, so we're going to have to nail it down? Have you seen any variation in that?
Yeah, that's a really interesting point. I was surprised that this decision came down in the 11th Circuit like this. It's not the most progressive circuit historically.
Right.
So I think that the progression is likely more that there's a concern that that it's enough to chill. And I think that that's probably where things are moving. The issue, you know, so there's two things going on when somebody says my First and Sixth Amendment rights were violated. You know, my legal mail could have been read or my legal mail was read. Oh, and so the two things going on are my conviction should be thrown out, or my indictment should be thrown out, or my case should be thrown out. And then the other side of that is I should be able to sue the jail and I should be compensated.
Okay,
So there's
yeah.
sort of these two things. They can proceed on you know, criminal case or civil case because, you know, we have those options. If we're looking at, you know, whether your case should be thrown out, the indictment should be thrown out. I'm thinking of a case that it was in one of the Bureau of Prisons. So the Bureau of Prisons federally uses the CoreLink system.
Okay.
The CoreLink system is an email system where you're emailing friends and family and your attorney. And in order to email with your attorney, you check a box that says that you waive attorney-client privilege. And yes, quite interesting. So attorneys tell their clients, don't send me anything on CoreLinks, please.
Right. Yes.
But they can't reach them on the phone. You know, the wait, maybe there's a Zoom wait, it's taking months. They've got something they really got to tell them, you know, so then they do, and then they forget. And next thing you know, their case information that they gave to their attorney is being used by the prosecutors in their case.
Right.
Directly. And, you know, I know you and I are going to talk about the Prison Oversight Act. I think that's a reason, one of the reasons that act is pending in the Senate, because those things are happening. So sort of an aside there, but If I was running a facility, I would try to do what I could to take myself out of the middle between the attorney and the person
Yes.
receiving the legal mail, for sure.
Yes.
Yeah.
Yes. And and of course it's as long as humans have been alive, I'm sure, but that constant battle between, you have enough freedom to do what you need, but that also means that someone who does have ill intent can manipulate that and do, like, for example, what you were talking about, the email thing, because technically the box was checked that said that you waive attorney-client privilege. So I'm a corrections officer. Hey, you checked the box. That's not on me. You checked it, and and that may sound good, but like you said, if all of a sudden, the prosecution's showing up with all this stuff that was, the inmate was under the impression that attorney-client privilege applied, even though they checked the box. I can imagine that would not hold for long when you're talking to a judge, that it was things were not on the up and up as they appeared. And so,
It's
yeah,
true. Yeah, and I'm kind of curious about, when you check that box, is it like when when you get those, new terms and conditions from Microsoft Teams, and it's like 7 pages, and you're like, scroll, 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 check. Who knows? But the the question that starts to get brought in there is this person getting effective assistance of counsel? If
right.
they don't have a way other than to open up their communications with everybody, do they have a way to talk to their attorney or work with their attorney? And that's, I guess it was 2022, it was the Effective Assistance of Counsel Act, which was very bipartisan, passed the House, and then didn't really get very far in the Senate. I'm not exactly sure why, but it seems like parts of that have become part of this new Prison Oversight Act, where it's kind of cool. Again, tech is so great. You can sign up for updates on what's happening with that bill. And it seems like every day there are new co-sponsors to that bill who are Republicans and Democrats. So I think it's pretty likely that the Prison Oversight Act is going to pass this year. And that relates to all of this legal mail because it requires facilities to have more accountability with respect to, what are the conditions in the facility? How frequently does the individual get to speak with their attorney? Are they getting effective assistance of counsel? Are they getting their legal mail? All of these questions.
Sure. And that is something that, again, just in my personal experience, those were always dealt with, that appeared piecemeal. You'd have somebody would sue about this, and so all of a sudden there'd be this scramble to fix this. Well, next year it would be this, and you felt like you were constantly having to reassess, reevaluate, look at policy, look at procedure, look at practice to see, oh, good grief, are we violating somebody's rights over here when we thought we had it fixed again? In theory, anyway, the thought of looking at it from a bigger picture, that sounds a lot like, it makes a lot more sense to me than like I said, the constant barrage of individual.
Yes.
And
things. Aaron, just to be clear, this federal bill only applies to the Bureau of Prisons. So, right. Those state-run facilities, but what we've seen happen since the Effective Assistance of Counsel Act, which actually started in 2021, is we've seen these commissions arise in different states, prison oversight commissions, Arizona, Hawaii, Alabama, Virginia, Minnesota. There are many. And these oversight commissions, maybe they arose out of things that happened during COVID. I'm not sure. Maybe it's a budgeting thing, but there's a lot more attention paid to what's going on in these facilities because we hear about lockdowns post-COVID, and we hear about problems with staffing, understaffing, and danger and deaths in facilities. And so so even though the one we've been talking about is federal, there are a lot of commissions that will be, I would expect that they would use the same rubric that the feds use to start looking at the state-run prisons. And then there's the Martha Wright Reed Just and Reasonable Communications Act of 2022. So that was a new law that was passed in 2022 that said that the FCC has the authority to regulate video calls to and from correctional facilities and regular phone calls. So before that, we heard that there were, it was very expensive to make phone calls from facilities. So it ratcheted down on that. But it also applies to video. And that's all rolled up into effective assistance of counsel and communication with counsel. And so what that bill did was it said that I think they have 24 months from January 2022. So by January 2024, the FCC has to create regulations that everyone will have to abide by, that take into account the costs associated with any safety and security measures necessary to provide video calling service. So for attorney-client calls, this means that many of the current systems that do charge folks for calling of attorneys, they may be scrutinized.
Now, from what you're seeing, I mean, again, they're still in the process, but from a practical side of things, what would you see as potential results for jails, prisons, as far as how they adjust? Would it be primarily contract with the vendors that are providing these services, or would it be actual practice within the facility? That's probably, again, I know this is your opinion, but would you see that might need to adjust?
I think that it's just something that everybody should be, keeping in mind as part of the big picture. And I think that, the truth is that video calling is not free. I mean, it's not free. And it's more powerful than speaking to somebody on the phone, with something we've all become much more used to. And especially for attorneys and clients, there's something about being able to see somebody's face when they say certain words.
Sure.
Not only do you feel like you understand them more, but you can either believe them more or not believe them. And that's important, because a jury is going to have the same reaction.
Yes.
And for you as the attorney to be able to say, oh, wow, when they said that to me, they just really look like they were just not telling the truth. And that's how a jury's going to take it too. So I better, give them some wise counsel about, where their case may end up. So does effective assistance of counsel, can you achieve it on a phone call the same way you can achieve it via video call? I would say probably not. Some people would probably argue you need to even be face to face. Personally, I don't think that's necessary. But so I do think that in order to make sure that your incarcerated population is getting effective assistance of counsel, I would say have a video option. And then, make sure that your vendor is following, what's happening here. But I also see it as a real opportunity for the attorneys to start paying some of these costs too. And, public defenders, they save a lot of money when they don't have to drive to the facility, and they don't have to sit and wait to see their client, and they don't have to go through security. And so it makes sense that this should not be a burden only borne by the facility.
Right. And and just kind of in light of this, segueing a little bit, in your experience and seeing what you have seen thus far, and then seeing where it's the laws that are being passed, the cases that are coming up, when it comes to use of technology and interaction with an attorney, play the hypothetical. I'm a jail administrator. I don't know anything about technology other than, it's an app on my phone that I press and this happens. Um, and now I've got a facility and I have this vendor coming in saying, hey, we provide secure video visits and phone calls, etc., including attorney-client conversations. So we've got this. You let us put our equipment in. What are some things that I, as an administrator, would need to double check to make sure that I'm not walking into an ambush when it comes to technology use and attorney-client privilege?
Oh, that's such a good question. First of all, I would say, is that vendor willing to indemnify you if there is a violation that is found that has anything to do with what the vendor is providing? So I think that's number one.
Okay.
So if they're not, the writing's on the wall, but if they are, if they're
Big
saying
flag.
like the way we do it. So I can tell you like what we do at Lighting Law.
Okay.
Because I think these are the things you'd want to look for.
Okay.
Number one, only their attorney can talk to the individual. It's one-on-one. No one else can join. Like you and I are in this Teams meeting, you can invite a guest, I can invite another guest. It's impossible in our due process app. That attorney has to be screened by the jail during doing their typical thing. And that's on the facility. At Lightning Law, we don't know who represents who unless, if they just tell us that, great. But that's really, your facility, the attorneys in the community.
Yes.
So you vet those folks, you give them a code. That's the code they can use to get in. And we don't have virtual backgrounds. It's very important that you can see what's happening. We don't record the meetings. Attorney-client privileged communication should never be recorded.
Right.
We don't gather any information from the conversations for AI use, which we heard recently about Zoom doing. And then Zoom has been in the news for, they had a new term of service where they said that they would be archiving conversations for AI improvement.
Ooh. Wow.
Yeah.
Okay.
So I think, so in addition to the indemnification, making sure no one else can enter, making sure no one else can read those documents. So the attorney uploads the documents, are shared with they can only be shared with the incarcerated individual. Okay. That person who is incarcerated, they can make notes and annotations on their documents, but as soon as they close that document or the program, those annotations disappear. There were concerns that there may be attempts to pass along messages, so those annotations only reappear during the video call. Okay. There are no links to the outside world. Those are all security issues that don't really have anything to do with attorney-client privilege, but the stuff that we can't control is, if they're in the facility, they should be given a place with their tablet to have that call so that they don't have to worry about someone looking over their shoulder or listening to them.
Sure. So it puts the burden on the jail primarily at the approval of the attorney to use the system. And then basically the system provides the safeguards, I guess you would say, that keeps everybody out of trouble, rather than because I know, again, with just pulling on my experience, any video calls that the inmates used, it was a part of the setup is that they would have to notify us, this email or this phone number is my attorney. Okay, then we could verify, yes, email, phone number, whichever, or both, our attorney. And then we would flag that account as an attorney so it did not record like it would normally. But there are a
Right.
few occasions, specifically when you had someone where English wasn't their first language that did not understand that process and would just go into a conversation with their attorney. You have an officer that's just going through checking videos, making sure nobody's doing something they're not supposed to be doing on video, and all of a sudden realizing, oh my word, that this is a client and an attorney. And now, they would get out of it, and you could see how long they looked at the video. You could see how long they were logged into that. And then we'd notify the attorney, notify the inmate, hey, bud, you need to get us this information. But that always concerned me, because that 10, 15, 20 seconds that officer could see and hear, it wouldn't take much of a stretch for someone to say, hey, wait a minute, like you said earlier, they could hypothetically use information.
Yes.
So that is awesome. So the to kind of bring this full circle and wrap this up, what are some things that you see coming down the pike, so to speak, that jail administrators might want to make sure they keep on their radar?
I would say that, one of the things you were talking about is technology, and the use of technology. The use of technology to try to start to take some burdens off the jail,
Right.
and reduce costs. I think jails are starting to, and will soon be expected to, kind of become more tech savvy and use their funding or use their budget in such a way. And along with that will come obtaining data, using systems where you can gather data so that you can use it to report. So that you don't have to do all these handwritten audits, or, so that when you're audited, you can say, we use this system. The report shows that this person was able to speak with their attorney for 10 hours each month and open their own documents and do that kind of thing. So I would say, if I were a jail administrator, I would be interested in attending some seminars or programs that were specifically geared toward technological improvements and changes in jail infrastructure and reporting and data. So something maybe for JailCon to even think about. For attorneys, a couple years ago, the American Bar Association said it's now part of your rules of professional accountability. You have to become tech savvy. The attorney that doesn't know how to do a remote deposition, they need to figure it out. The attorney that doesn't know how to research online, they need to figure it out. So now it's part of what we do. I think that, like, the implication is that it's essentially, part of what a jail will be expected to do. And maybe that's just like bringing in younger people to help, our children, essentially. How do I turn this thing on?
Yeah.
Yeah. So that's another thing that I see. It is, when you think about technology and security, a lot has changed. It used to be when you left your home for a long trip, you would have a neighbor watch it and get your mail and, get your packages and do all that stuff. And now you've got Ring cameras, you've got security, like you have all these things. So I think it's moving in a similar direction, probably, for some jail operations. I mean, you would know better than I would.
Well, and I'll tell you, from a jail perspective, you mentioned, the recognition of staffing issues. And one of the things that the technology has facilitated is that you can maintain the level of control as far as observation and visual, even in some case audio, through technology that would have required, I'm going to have 4, 5, 6 officers with salary and retirement and insurance and so forth and so on. Well, when you add up 5, 6, 7 officers and all their benefit package, this technology becomes very affordable now. And I don't necessarily have to have as many officers on the floor as I did before. So there, you know, I know there are those that, they hear the word technology and they want to run away screaming. But there are huge benefits to that from a practical perspective. But based on what I'm hearing in our conversation here, that okay, technology is great, it can help, but you better make sure that your I's are dotted and your T's are crossed, because you may be waltzing into something that would have been worse than having the
Yeah.
5 or 6 officers doing whatever it is they're doing.
Yeah. Yeah, I think I particularly appreciate technology that is created or run by people who are specialists in that field, you
Sure.
know.
Yeah. Yes.
And I think this is one of those areas where you have the opportunity to, oh, these people do attorney-client conversations for all kinds of attorneys and their clients. Let them deal with this. I don't want, but let them, indemnify me if it's on
Yes.
their end. So
Yes.
yeah. No, I think it is exciting that technology can help with the staffing shortages, because those are a real thing. And
Right.
and the, wanting to run away screaming, I get it, but there's so much innovation that can be done in this particular field, and that can help with everybody's day-to-day happiness level. So I hear again and again that when the population is calmer and happier and feels safe, when they feel like their needs are met, they feel like they can speak to their attorney, they feel that they feel respected and that their rights are being appreciated, then they're, less violent, they're easier to
Yes.
work with, and then that reflects on staff. So in a perfect world, incarcerated individuals would have little, blood pressure monitors, like those little heart rate monitors, and could
Yes.
see, how you're doing. Yeah.
Well, awesome. Well, any other thoughts on the topic as we wrap up the conversation?
No, not really. We should definitely watch and see what happens with the Christmas case. And frankly, kudos to that defendant plaintiff for being savvy enough to think about these things.
Yes. Well, and if you're willing, with when we do get some decisions on that case, I may holler back at you, and we could revisit this conversation based on that decision.
Yes, let's do that. And I can also keep track of which courts refer to that decision in making new law as well. So what impact that is having. Yeah. Yeah, I would
Awesome.
say, biggest takeaway, let's get the jails out from in between the attorneys and the clients, and let that digital mail just flow.
Yes. Yes. Well, good deal. Well, I thank you very much for being
Thank
willing to
you.
do this, and I will, and if you're willing, I may throw a question or two your direction as we continue to delve into this, because this is something that, well, now that I'm not actively in the industry as far as a jail administrator, it's a non-entity, but as someone who consults and trains and so forth and so on with jail administrators, obviously it needs to be in my thinking. I had not realized the extent to which Pandora's box had been opened in some cases when it comes to liability. Because you go back to, hey, I've got a vendor for that. That's what they do, and it may be that they're not. so
Yeah. Awesome. Yeah. The Zoom in Teams are really business tools created for business operations.
Right.
Yeah.
Well, good deal.
Thank you, Aaron,
awesome.
for inviting me to speak, and I look forward to our next conversation.
Well, all right, guys. I trust that there was some pieces in last week's interview and this week's interview that were informative. Again, like I said at the beginning, there were parts of it that I was not aware of, and just in the conversation with Alisa, kind of shocked me. It made me realize that how precarious the situation can be when it comes to dealing with attorney-client privilege, legal mail, and making sure that we're following the letter of the law when it comes to that. So a very special thank you to Miss Alisa Brodkowitz with Lightning Law for being willing to come on the podcast and discuss this with us. And so, as always, guys, it's a pleasure to be with you, and I hope, as always, that you gain something out of it. And until the next time, guys, stay sharp, stay safe, stay vigilant. Godspeed.